The night Denise Carter finally held the keys to her new home, she slept with them in her fist, because 3 days later, a man with more money than conscience would look her in the eye and tell her the house was never hers to begin with. This is the story of how one woman's 20 years of sacrifice collided with one man's arrogance, and how a debt paid in secret, years before either of them knew it, would come back to settle the score in a courtroom nobody expected to change. Denise Carter was 42 years old, and she had been renting her whole adult life. She worked 12-hour shifts as a licensed practical nurse at Cedarview Medical Center in a mid-sized city called Ashcombe, the kind of place with an old downtown. A new stadium the taxpayers were still paying off, and a widening gap between the neighborhoods that got new sidewalks and the ones that didn't. Denise lived in the ones that didn't. She had raised her son, Malik, mostly alone after his father drifted out of the picture when the boy was 6. She'd worked doubles on Thanksgiving so he could have new sneakers for school. She'd eaten off his plate more nights than she'd admit, telling him she wasn't that hungry, so there'd be enough. Malik was 22 now, in his second year of community college, studying to be an electrician. And Denise had a number in her head that she had been chasing for 19 years, $41,000. That was the down payment she had scraped together, dollar by dollar, shift by shift, coupon by coupon. She kept it in a credit union account she'd nicknamed, in her own private ledger, the house fund. She did not touch it for anything, not for Malik's braces, not for the transmission that went out on her Corolla, not even the year the roof of her rental apartment leaked black mold into her bedroom wall. She patched what she could and kept saving. Owning a home for Denise was never about granite countertops or square footage. It was about her mother, Ruth Carter, who had cleaned houses in the wealthy part of Ashcombe for 31 years and died in a rented apartment 2 months before her final rent-to-own promise from a landlord fell through, a promise that turned out to be worthless. Just like so many made-to-black families in that city over the decades, Denise had watched her mother work herself into the ground for a dream that never became paper and ink. She had promised herself at her mother's funeral that she would not die the same way. So when she found the house on Maple Ridge Lane, a handsome 2-story colonial with a wraparound porch, a magnolia tree in the front yard, and a for sale by owner sign hand-painted with gold trim, she felt something she rarely let herself feel: hope unguarded. The seller was a man named Franklin Whitmore. Whitmore was 58, silver-haired, tailored in a way that made his suits look like armor. He sat on the Ashcombe City Planning Commission, chaired the board of a regional bank, and had his name on a wing of the Children's Hospital. People in Ashcombe said his name the way you'd say a title. He didn't need to sell the Maple Ridge house. It was one of 9 properties he owned across the county, but he liked buying distressed properties, fixing them just enough to look finished, and flipping them for profit, often to people who could least afford a mistake and were least likely to fight back. When Denise walked through the door for the first showing, Whitmore greeted her with a smile that didn't reach his eyes. "Well, isn't this a treat?" he said, looking her up and down. "Don't get many folks like you looking at a street like this." Denise let it slide. She had learned, over 4 decades of being underestimated, when to let something slide and when to hold it in her pocket for later. She held this one in her pocket. The negotiations took 6 weeks. Whitmore's assistant handled most of the paperwork, a stack of documents thick enough to double as a doorstop, full of legal language Denise didn't fully understand but trusted, because the man across the table was a planning commissioner, a bank chairman, a name on a hospital wall. Surely a man like that didn't need to cheat a nurse out of her savings. She was wrong. Buried in page 14 of a purchase agreement in a paragraph titled Conditional Occupancy and Title Transfer Addendum was language that essentially reserved Whitmore the right to retain legal title to the property pending satisfactory completion of seller's outstanding financing obligations. A clause so vague and so quietly worded that Denise's own signature on it, made in good faith, gave him a door to walk back through whenever he wanted. She handed over her $41,000 down payment. She signed a promissory note for the remaining balance, financed privately through Whitmore himself at his insistence. "Saves you the bank fees, sweetheart," he'd said, patting her hand in a way that made her skin crawl. She moved her furniture in on a Saturday in April. Malik carried boxes up the porch steps 2 at a time, grinning, saying, "Ma, we did it. We actually did it." 3 weeks later, a locksmith Denise had never met changed the locks while she was at work. She stood on her own porch that evening, keys that no longer worked trembling in her hand, staring at a brass lock that gleamed like it was mocking her. She called Whitmore. He didn't answer. She called his office. His assistant, a young woman with a voice like a closed door, told her that Mr. Whitmore is reassessing the terms of the sale and that Denise should expect correspondence from legal counsel. The correspondence, when it came, was 2 pages long. It stated that Denise had defaulted on undisclosed financing conditions, that the sale was rescinded pending review, and that her $41,000 deposit would be treated as forfeited earnest money in accordance with Section 14 of the executed agreement. Denise read that letter 9 times in her car in the Cedarview parking lot before her next shift, her hands shaking so hard she had to grip the steering wheel to steady them. $41,000, 19 years. Gone on paper, in a sentence written by someone who had never missed a meal in his life. She went to the police. An officer took her statement with visible impatience, told her it was a civil matter, and suggested she get a lawyer in a tone that suggested he already knew she couldn't afford one. She went to 3 attorneys' offices in Ashcombe. The first one glanced at the contract for 4 minutes and told her Whitmore's paperwork was airtight and that fighting him would cost more than she'd win back. The second one didn't return her calls after the first meeting. The third, a young man fresh out of law school, took her case for a retainer she didn't have and quietly dropped it 2 weeks later after what he vaguely called a conversation with opposing counsel. She never learned what was said in that conversation. She had her suspicions. Word moved through the neighborhood the way word does. Some of it was sympathetic, much of it was not. She probably didn't read what she signed. You know how these house-flipping deals go, somebody always gets burned. Maybe she couldn't really afford it in the first place. At the grocery store, a woman she'd known for years, not unkindly but carelessly, said, "Denise, honey, maybe it's a sign. Maple Ridge was never really for people like us anyway." That sentence stayed lodged in Denise's chest like a splinter she couldn't dig out. She filed a small claims complaint on her own, using forms she printed at the library, staying up past midnight after 12-hour shifts to fill them out by hand because she couldn't afford a lawyer and refused to let this go unanswered. The case was bumped up to circuit court because of the dollar amount involved. A court date was set. Denise told herself, "At least I'll get my day, at least someone will finally have to listen." She was wrong about that too at first. The courtroom smelled like old wood polish and cold air conditioning. Denise wore her one good blazer, navy blue, bought for Malik's high school graduation. She sat at the plaintiff's table alone, a manila folder of bank statements and copied letters in front of her, her hands folded so tightly her knuckles had gone pale. Across the aisle, Franklin Whitmore sat beside a lawyer named Gregory Pierce, sharp-suited, smooth-voiced, the kind of attorney who billed more per hour than Denise made in a week. Whitmore didn't look nervous. He looked bored, the way a man looks bored when he's already certain how something ends. The judge was the Honorable Eleanor Pratt, a woman in her early 60s who had presided over Ashcombe's civil docket for 11 years and had over that time developed the particular fatigue of someone who has seen 1,000 disputes and stopped being surprised by any of them. "Ms. Carter," Judge Pratt said, glancing at the file in front of her without much interest, "you're representing yourself today." "Yes, Your Honor, I couldn't find an attorney to take the case." A small, almost imperceptible exchange of glances passed between the judge and the opposing table. Pierce didn't bother hiding a faint smile. Denise tried to explain. She described the addendum, the locksmith, the $41,000. Her voice cracked once, and she hated herself for it, because she saw the way the judge's eyes flicked toward the clock on the wall, and the way the bailiff shifted his weight like he was waiting for something more efficient to happen. Pierce rose smoothly. "Your Honor, my client is a respected member of this community who has, out of generosity, tried to work with Ms. Carter on a private financing arrangement that ultimately fell through due to her own default. The contract is unambiguous. Ms. Carter signed every page." "I didn't understand what that paragraph meant," Denise said. "Nobody explained it to me. He told me it was just standard language." "Ms. Carter," Judge Pratt said, not unkindly, but with the flat patience of someone repeating something she'd said many times before, "ignorance of a contract's terms is not typically grounds for—" "I'm not ignorant," Denise said, sharper than she meant to. The word had lit something in her. "I read every page. I understood. I trusted a man who sat on the planning commission to not bury a trap on page 14. A ripple of murmurs went through the gallery. Judge Pratt's expression cooled. "I'll ask you to control your tone in my courtroom." Denise looked down at her folder, her cheeks burning. She had waited months for this day, imagined 100 times how she would finally be heard, and instead she felt smaller than she had in the grocery store, smaller than she had on her own dark porch with a key that didn't work. The hearing lasted less than 40 minutes. Judge Pratt, citing the complexity of the financing arrangement and insufficient documentation presented by the plaintiff, continued the case for further review and almost as an afterthought suggested Denise seek proper legal counsel before the next hearing for her own benefit. As Denise gathered her folder, she heard Pierce murmur to Whitmore, not quite quiet enough, "Told you, no lawyer's going to touch this. She'll fold before the next date." Whitmore chuckled, buttoning his jacket like a man closing a door on a conversation that had never really mattered to him. Denise walked out of that courthouse and sat in her car for 20 minutes before she could make her hands stop shaking enough to drive. To understand what happened next, you have to go back 6 years, to a rain-soaked afternoon on Route 9 outside Ashcombe, to a moment Denise Carter had almost forgotten because she had never once treated it as something worth remembering. She had been driving home from a nursing shift, exhausted, rain hammering her windshield, when she saw a minivan hydroplane across 2 lanes and flip onto its side in the median, sliding into the guardrail with a shriek of metal that she still, on quiet nights, heard in her sleep. Denise didn't think. She pulled over, ran through the rain in her scrubs, and found a woman unconscious behind the wheel, bleeding but breathing, and in the back seat, hanging upside down in her car seat, screaming, a little girl no older than 4. The van's back door was jammed. Denise remembered the smell of gasoline, remembered her hands slicing open on broken glass as she wrenched the door frame apart with strength she didn't know she had. Remembered unbuckling the child with fingers slippery with blood, her own blood, and pulling her free, seconds, maybe less, before flames licked up from the engine well. She carried the little girl 50 yards from the wreck and shielded her body with her own as the van caught fire behind them. She stayed with the mother until paramedics arrived, gave a statement to a state trooper, and refused a ride to the hospital for her own injuries because her shift started in 3 hours and she couldn't afford to miss it. A local paper ran a small item 2 days later, off-duty nurse praised for roadside rescue. Denise never gave an interview. She didn't want the attention, she'd done what anyone should do, she said, and went back to work with 16 stitches in her palm hidden under a glove. She never learned the little girl's name. She never asked whose daughter she was. She simply went home, cleaned her wound in the bathroom sink, and never spoke of it again. The little girl's name was Ava Rain, and her father, who had been 3 states away at a legal conference the day of the accident, who had returned home to find his wife in a hospital bed and his daughter alive because of a stranger who vanished before he could even learn her name, was a man named Marcus Rain, a man who 6 years later would become the single most feared and respected attorney in the entire state. Marcus Rain was 51 years old, and in the world of Ashcombe law, his name did not need an introduction. He had grown up on the same side of the city Denise had, the son of a postal worker and a schoolteacher, the first in his family to attend law school. He'd clerked for a federal appellate judge. Spent a decade as a civil rights litigator taking on housing discrimination cases most firms wouldn't touch, and eventually built his own practice that specialized in exposing exactly the kind of quiet paperwork-buried fraud that powerful men like Franklin Whitmore had built entire careers hiding behind. 3 years ago, his peers had elected him president of the State Bar Association, a position that made him, in practical terms, one of the most influential legal figures in the state. Someone judges did not take lightly because Marcus Rain's reputation for meticulous, devastating preparation preceded him into every courtroom he entered. Attorneys joked, half seriously, that opposing Marcus Rain wasn't a case, it was a controlled demolition. But Marcus never forgot where he came from. And he never forgot the woman who had saved his daughter's life and disappeared into the rain without asking for anything in return. He had spent months after the accident trying to find her. The state trooper's report had her first name misspelled and no forwarding information, and the newspaper reporter who wrote the item had since left the paper. Marcus had eventually hired an investigator quietly, without his wife's knowledge at first, because he needed to look this woman in the eye and thank her the way a stranger's silence didn't deserve to go unanswered. The trail went cold. Life moved forward. Ava turned 5, then 8, then 10, growing up with a jagged little scar on her forearm from the accident and a father who told her every single year on the anniversary, "Somebody out there gave you your whole life, baby girl. Don't you ever forget that." Marcus never stopped wondering who she was. He found out by accident, the kind of coincidence real life sometimes hands you when you least expect it. His paralegal, a sharp young woman named Priya who volunteered at a legal aid clinic on weekends, mentioned over coffee one Monday morning that she'd sat in on a hearing that had bothered her all weekend. This woman represented herself, Priya said. Circuit court. Some real estate fraud thing with Franklin Whitmore, you know him, the planning commissioner. She didn't stand a chance. Judge barely let her talk. I felt sick watching it. Marcus's ears caught on the name Whitmore. He'd had his own history with the man, had represented 2 other families years back who'd been quietly squeezed out of properties through similarly buried contract language. Cases that had settled before trial with confidentiality clauses that kept Whitmore's name clean. But it was the next detail that stopped him cold. What was her name? Marcus asked. Priya checked her notes. Denise Carter. Marcus felt something shift in his chest, a memory surfacing that he hadn't let himself sit with in years. Carter, he repeated. She work at Cedarview Medical Center? Nurse. Priya blinked. Yeah, actually, how'd you know that? Marcus didn't answer right away. He was already reaching for his coat. He found her at Cedarview 3 days later, On her lunch break, sitting alone in the hospital cafeteria with a cup of coffee she wasn't drinking, and a stack of court papers she'd read so many times the corners had gone soft. Ms. Carter. She looked up at a tall man in an unassuming gray suit, no tie, reading glasses pushed up into salt and pepper hair. She didn't recognize him. "Can I help you? My name is Marcus Rain, I'm an attorney." He watched her face close slightly, the practiced wariness of a woman who'd had enough of lawyers who wouldn't help her and lawyers on the other side who were actively hurting her. "I'm not here to sell you anything, and I'm not working for Franklin Whitmore," he added gently. "I heard about your case, I'd like to ask you something if that's all right." Denise gestured to the seat across from her, cautious. "6 years ago," Marcus said, "on Route 9 during a storm there was an accident. A minivan flipped in the median." Denise went very still. "A nurse pulled a little girl out of that van before it caught fire," Marcus continued, his voice tightening despite 30 years of courtroom composure. "She cut her hands doing it, she didn't give her name to the papers, she just left." Denise's coffee cup trembled slightly in her hand. "That was a long time ago," she said quietly. "That little girl," Marcus said, "was my daughter, Ava. She's 10 now. She still has a scar on her arm, and every year on the anniversary of that day, I tell her that a stranger gave her the rest of her life." His voice broke just slightly, in a way that surprised even him. "I have spent 6 years trying to find you, Ms. Carter. And I find out you're sitting in a courtroom, being humiliated by a man who spent his whole life stepping on people like you, and nobody in that room is willing to see you." Denise's eyes filled, and for the first time in months it wasn't from exhaustion or shame. "I didn't do it to be found," she said. "I did it because it was the right thing." "I know," Marcus said. "That's exactly why I'm not going to let them bury you the way they buried the truth about what you did that day." He slid a business card across the table. It read, "Marcus T. Rain, President, State Bar Association." Denise stared at it for a long moment. She started. "I'm your lawyer now," Marcus said. "If you'll have me, no fee, not after what you did for my family. This isn't charity, Ms. Carter, this is a debt I've been waiting 6 years to pay." For the first time since the locksmith changed her locks, Denise Carter allowed herself to cry in front of another person. Marcus Rain did not walk into courtrooms unprepared, and he did not intend to start now. He spent the next 3 weeks with a small team, Priya, a forensic accountant named Ruth Delgado, and a retired title examiner named Walter Acaffer, who had spent 40 years reading exactly the kind of buried clause contracts Whitmore specialized in, tearing apart every document connected to the Maple Ridge sale. What they found was worse than even Denise had suspected. The conditional occupancy and title transfer addendum wasn't standard language at all. It was custom drafted by Whitmore's own attorney, and had appeared under slightly different wording in at least 4 other property sales over the past 9 years, every single one involving a first-time black homebuyer. Every single one ending in a rescinded sale after the buyer had already paid a substantial deposit. In 2 of those cases, Whitmore had resold the same property within 8 months for a higher price. Walter Acaffer, examining the county recorder's records, discovered something even more damning. Whitmore had never actually held clear, transferable title to the Maple Ridge house at the time he sold it to Denise. There was an unresolved lien from a business partner dispute 3 years earlier. A lien Whitmore had quietly negotiated to have resolved only after collecting Denise's $41,000 deposit, meaning that for weeks, Whitmore had knowingly sold Denise a house he did not have the legal right to sell, and had used her deposit in part to help clear his own debt. "This isn't a contract dispute," Marcus told Denise, spreading the documents across his conference table one evening, while Ava, now 10, sat in the corner doing homework, occasionally glancing up at the woman her father kept calling a hero, trying to understand why this quiet, tired-looking woman made her father's voice shake. "This is fraud. Deliberate, repeated, documented fraud. And Franklin Whitmore has been getting away with it because every single person he's done it to has been someone he assumed wouldn't fight back or couldn't afford to." "Why didn't any of those other families sue him?" Denise asked. "2 of them tried," Marcus said grimly. "They settled quietly under confidentiality agreements for a fraction of what they lost, because they couldn't survive a prolonged legal fight against a man with his resources. One of them," he added more quietly, "gave up entirely and moved out of state." Denise looked at the stack of names, strangers but not strangers, people who had stood exactly where she'd stood, humiliated in exactly the ways she'd been humiliated. "Then we don't settle," she said. "Whatever it costs, I want it in front of a jury. I want it on the record." Marcus smiled, the first real smile she'd seen from him. "That," he said, "is exactly what I was hoping you'd say." When the case was called back before Judge Eleanor Pratt 6 weeks later, the courtroom looked different before a single word was spoken. Franklin Whitmore arrived in his usual tailored confidence, Gregory Pierce at his side, both men settling into their seats with the easy comfort of people who'd already decided how the day would go. Then the doors opened, and Marcus Rain walked in. The change in the room was immediate and visible. The bailiff straightened. Two younger attorneys waiting on an unrelated matter in the gallery sat up and began whispering to each other. Even Judge Pratt's posture shifted, not fear exactly, but the particular alertness of a judge who knows the day just became a great deal more complicated. "Mr. Rain," Judge Pratt said, an eyebrow raised. "I wasn't aware the Bar Association had taken an interest in a circuit court contract dispute. I'm not here as bar president, Your Honor," Marcus said, setting down a leather case thick with binders. "I'm here as counsel of record for the plaintiff, Ms. Denise Carter." Gregory Pierce's confident expression flickered just slightly, like a man who has just heard a sound he didn't expect from underneath his own house. Whitmore leaned toward Pierce and murmured something. Pierce didn't answer. "Your Honor," Marcus continued, "I've filed an amended complaint. This is no longer a simple breach of contract matter. We are alleging fraud, deceptive real estate practices, and a pattern of predatory conduct spanning multiple transactions over nearly a decade. I'd ask the court's indulgence as we lay out the evidence." Judge Pratt studied him for a long moment, then really looked for the first time at Denise, sitting straight-backed beside her new counsel, folder gone, replaced by nothing, because she no longer needed to carry her own defense alone. "Proceed, counselor," Judge Pratt said. The trial took 4 days. Marcus Rain did not raise his voice once. He didn't need to. On the first day, Ruth Delgado, the forensic accountant, walked the jury through the financial trail, the timeline showing Whitmore had accepted Denise's deposit, while an unresolved lien still clouded the property's title, and how a portion of that money had moved within 9 days into an account used to settle Whitmore's private business dispute. "In plain terms," Marcus asked her, "did Mr. Whitmore have the legal right to sell that property to my client on the date he accepted her $41,000 deposit?" "No," Delgado answered. "He did not." On the second day, Walter Acaffer testified about the pattern, the 4 prior sales with nearly identical addendum language, 3 of them to first-time black homebuyers, 2 of which had ended in the same rescission outcome after deposits were collected. Pierce objected repeatedly, arguing the prior transactions were irrelevant. Judge Pratt, visibly more measured now, more careful, more willing to actually weigh an objection than dismiss it on instinct, allowed the pattern evidence in, ruling it went directly to intent. On the third day, Marcus called Franklin Whitmore to the stand. It was, by every account of those in the gallery that day, the most devastating cross-examination Ashcomb's courthouse had seen in a decade. "Mr. Whitmore," Marcus began, calm as still water, "you told Ms. Carter that the financing addendum on page 14 was, in your words, standard language. Is that correct?" "That's my recollection, yes." "Is it standard language, Mr. Whitmore?" "I believe similar language appears in various. I'd like to show you Plaintiff's Exhibit 12. Marcus placed 4 contracts side by side on the display screen, dates spanning 9 years, addendum language nearly identical in each. "These are 4 property sales you personally negotiated. Do you recognize them?" A long pause. "I'd have to review them." "You drafted 3 of these addendums personally, correct? Your assistant's email, which we've entered as Exhibit 14, confirms you dictated this exact paragraph to your attorney for insertion into the Carter contract, calling it, and I quote, the safety net language, same as the Fenwick and Alvarez deals." Whitmore's jaw tightened. "I don't recall the specific wording of that email." "You don't recall writing an email you sent 11 weeks ago?" Pierce rose. "Objection, badgering." "Withdrawn," Marcus said smoothly, already moving on, never breaking stride. "Mr. Whitmore, isn't it true that at the time you accepted Ms. Carter's deposit, you were aware of an unresolved lien on the Maple Ridge property stemming from your dispute with a former business partner?" Silence stretched a beat too long. "There was a minor administrative matter regarding title, yes." "A minor administrative matter," Marcus repeated, letting the words hang in the air like smoke. "Mr. Whitmore, did you use any portion of Ms. Carter's $41,000 deposit to help resolve that lien?" "I don't see how that's." "Your Honor, I'll direct the witness to answer." Judge Pratt, without hesitation now, "Answer the question, Mr. Whitmore." Whitmore's silver composure cracked for the first time in the entire proceeding. There may have been some overlap in the timing of funds. A ripple went through the gallery. Denise sat very still, watching a man who had once patted her hand and called her sweetheart, now visibly sweating under lights he had never once imagined would find him. "One more question, Mr. Whitmore," Marcus said, quieter now and somehow more devastating for it. "When you looked across that negotiating table at Denise Carter, a woman who had saved for 19 years for that down payment, did it ever cross your mind that she might fight back?" Pierce shot up. "Objection, argumentative, calls for speculation," sustained, Judge Pratt said, but she was looking at Whitmore with an expression that made clear the objection had come a beat too late to undo the question's damage. "The jury will disregard the last question. Move along, counselor." "No further questions," Marcus said, and returned to his seat beside Denise, who reached over and gripped his hand once hard before letting go. It was on the fourth day, during closing arguments, that the case's most unexpected turn arrived, not through Marcus but through the gallery. A woman Denise had never met rose from the back row during a brief recess, approached the bailiff, and asked to speak with plaintiff's counsel. Her name was Carol Alvarez, and her family's name Denise recognized instantly from Walter Acaffer's testimony, the Alvarez sale. One of the 4 prior transactions, one of the families who had settled quietly years before under a confidentiality clause Marcus had flagged as potentially unenforceable given the fraud allegations now on the record. "I saw the news coverage of this trial," Carol told Marcus and Denise in the hallway, her voice shaking but resolute. "I signed something years ago saying I wouldn't talk about what happened to my parents. But watching what he's doing to her," she nodded toward Denise, "I can't stay quiet anymore. I have documents. I have a recording of a phone call with Mr. Whitmore's assistant that we never used. I want to testify." Marcus moved quickly, filing an emergency motion to reopen testimony given newly available evidence directly relevant to the established pattern of fraud. Judge Pratt, after a tense sidebar and a visible flash of irritation at Pierce's overreaching objections, allowed it. Carol Alvarez took the stand the next morning and described in aching detail how her elderly parents had lost their own deposit on a home from Whitmore 8 years earlier. Nearly identical circumstances, nearly identical language, and a confidentiality settlement Whitmore's team had pressured them into signing while her father was recovering from a stroke. "So we wouldn't have to fight a man like that in a courtroom none of us thought would ever believe us." The recording she produced captured Whitmore's assistant explicitly referencing the standard rescission approach we've used before, the phrase, used before landing in the courtroom like a verdict already halfway written. By the time Carol Alvarez stepped down, Judge Pratt's expression had transformed entirely from the dismissive detachment of the first hearing into something closer to quiet fury. "Mr. Pierce," she said during a brief recess, loud enough for the gallery to catch, "I trust your client understands the gravity of what's now on this record." Pierce did not respond. He had gone very quiet. Marcus Rain's closing argument lasted 18 minutes, and every person in that courtroom, the jury, the gallery, even the bailiff who had presided over hundreds of trials, would later say it was the kind of closing they would remember for the rest of their careers. He didn't raise his voice. He didn't need theatrics. He simply told the truth plainly and let the truth do what powerful men like Whitmore had spent their whole lives betting the truth would never do in a room like this: win. Denise Carter did not walk into this courtroom asking for anything that wasn't already hers, Marcus said, standing before the jury, his hand resting briefly on the edge of the plaintiff's table where Denise sat back straight, eyes clear. She spent 19 years saving $1 at a time for a life her own mother never got to have. She trusted a man whose name is on a hospital wing, whose title is commissioner, whose signature was supposed to mean something. And when that trust was betrayed, when the deposit was taken and the locks were changed and the house was stolen out from under her in broad daylight, dressed up in legal language so that it would look on paper like something other than theft, she did not have the luxury of walking away. She could not afford to. She sat in this very room months ago and was told, without anyone quite saying it out loud, that a woman who looked like her, who worked like her, who had saved like her, could not possibly be telling the truth about a man who looked like him. Marcus let that sentence settle heavy over the jury box. That is not justice, that is a reflex, and this trial has proven beyond any reasonable doubt that the reflex was wrong. You have seen the pattern: 4 families, 9 years, the same buried clause, the same administrative matter, the same assumption that people without power don't fight back. You have heard in his own assistant's recorded words that this was not a mistake, it was a method. Denise Carter is not asking you for sympathy. She is asking you for what is owed to her, the home she paid for, the dignity that was taken from her in a public courtroom before this trial even began, and a judgment loud enough that the next Denise Carter and the next Carol Alvarez will not have to fight this fight alone. He paused, looking each juror in the eye one at a time. The law is supposed to protect people, not titles. Today I'm asking you to make sure it finally does. He returned to his seat. The courtroom was utterly silent. The jury deliberated for 6 hours. Denise sat in the hallway outside the courtroom, Marcus beside her, Ava, who had come with her father that day, sitting quietly through the final testimony with a 10-year-old solemn understanding that something important was happening, resting her head against Denise's shoulder without being asked to. "You scared?" Ava asked her quietly. "A little," Denise admitted. "My dad says you're the bravest person he knows," Ava said. "I think he's right." When the jury filed back in, Denise stood between Marcus and an empty chair that had once held every ounce of loneliness she'd carried into that first hearing. Now it just held her folder, closed, unnecessary. The foreperson read the verdict. On the fraud claim, liable. On the breach of contract claim, liable. On the claim of deceptive real estate practices, liable. On the claim of intentional infliction of emotional distress, liable. The jury awarded Denise the return of her $41,000 deposit, full transfer of clear title to the Maple Ridge house, compensatory damages for emotional suffering, and after Judge Pratt's own pointed instructions regarding the documented pattern of conduct, punitive damages that brought the total judgment past $1.2 million. Judge Pratt, before adjourning, looked directly at Denise for a long moment, the same woman she had once told to control her tone, the same woman she had once waved off toward proper legal counsel with barely concealed impatience. "Ms. Carter," Judge Pratt said, her voice steadier and more measured than it had ever been in this case, "I want the record to reflect that this court failed you at the outset of these proceedings. That failure will not be repeated in my courtroom again." She turned to the gallery, to the assembled clerks and attorneys and reporters who had begun filling the benches once word of the trial spread. "Let this judgment stand as a reminder to every person who has ever mistaken someone's silence for weakness or their patience for permission." Franklin Whitmore sat frozen at the defense table, the silver composure that had carried him through decades of quiet advantage finally, completely, gone. 6 weeks later, Denise Carter sat on the wraparound porch of the house on Maple Ridge Lane, a cup of coffee going cold in her hands, watching the late afternoon sun fall through the leaves of the magnolia tree in her front yard, her tree on her land under a deed that finally unambiguously bore her name. Malik sat beside her on the porch steps, home for the weekend, a paintbrush in his hand, touching up the trim on the railing. "You did it, Ma," he said. "You actually did it." "We did it," Denise corrected softly. A car pulled up out front, Marcus Raines with Ava in the back seat, waving through the window with the unrestrained enthusiasm only a 10-year-old can manage. They'd taken to visiting most Sundays now, an unlikely friendship grown out of an old debt finally paid. Marcus walked up the porch steps and handed Denise a small gift box, wrapped simply, no bow. Inside was a framed photograph, the newspaper clipping from 6 years earlier, off-duty nurse praised for roadside rescue, the one Denise had never even kept a copy of herself. "I found the original photographer," Marcus said. "Took me a while." Denise held the frame with both hands, tracing her thumb over the small, blurry photo of herself from years before she ever thought her name would matter to anyone beyond her own front door. "You didn't have to do any of this," she said quietly. "The case, this, any of it." "Yes, I did," Marcus said, sitting down on the porch step beside her, watching his daughter chase Malik around the magnolia tree, laughing, the scar on her forearm catching the afternoon light. "Some debts don't have a statute of limitations, Ms. Carter. Some of them you carry until you can finally set them right." Denise looked out over her yard, her porch, her tree, her name on a deed that no one could ever again pretend to erase. And for the first time since her mother's funeral, she let herself simply feel it. Not just victory, but belonging. Because justice delayed is not justice denied. Not when there is still someone left standing who refuses to let the truth stay buried.